forensic science experts present great benefits, such as a great possibility of digitizing the crime scene, allowing remote analysis through extended reality technologies, improvement in the accuracy and identification of biometric characteristics, portable equipment of on-site analysis, and Internet of Things devices that use artificial intelligence and machine learning techniques. These alternatives improves forensic investigations without demonizing the investors' promise and responsibility in the solution of cases. I'm going to pass now to Vasilios.
So thank you, Jersa Bejdo, for your actually remarks on the title. Now I would like to be very specific to Mr. Vasilo Tranfilo, that please let us know about that use of blockchain for data security. What is your view that how it can help us here?
Many years ago, good afternoon, good morning, to everybody. Good afternoon to India. Thank you very much for the invitation. It's really an honor. Good afternoon, dear Eminent colleagues. Let us know what it is, because in a dynamic space of digital forensics, the integration of artificial intelligence, R, and machine learning starts as a transformative technology, but also poisoned to amplify the efficiency and precision of digital forensics investigations. Here, if we go back in the 1990s and the brief synopsis of digital forensics, what became known as digital forensics was commonly termed computer forensics. The first computer forensics technicians were law enforcement officers, were also computer hobbyists. In the USA in 1984, work began in the FBI computer analysis and response, and as a response team to CART. 1 year later, in the UK, the Metropolitan Police set up a computer crime unit until John Austin with what was then called the Fraud Squad. A major change took place at the beginning of the 1990s and onwards. Investigations technician support operative with the UK law enforcement agencies, along with outside specialists, realized that digital forensics, as well as with other fields, required standards, techniques, protocols, and procedures. Apart from the informal guidelines, these formalists did not exist, but urgently, I can say, needed to be developed. A series of conferences initially convened by the Serious Fraud Office and the Inland Revenue took place at the Police Staff College and Bramshill in 1994 and 1995, during which the modern British digital forensic methodology was established. In the UK, in 1998, the Association of Chief Police Officers produced the first version of its good practice guide for digital evidence association of chief police officers in 2012. The ACPO guidelines detail the main principle applicable to all digital forensics for the law enforcement in the UK. But this does not apply only to the police. We have the role of the court, the leading decision, the contrary to scientific conclusions with the court judgments, and so many things. And also, we also have what is the role and what is the scientific method of scientific laws. The aim of science is to make order out of chaos by producing explanations for what we see around us. These explanations come into the form of rules of law, or law, which we hope once described are universally true. For example, objects or whatever weight dropped from a tower or other high point will always fall at the same rate, assuming the same resistance, and that the rate can be described by a scientific formula. We can also say that this is a part of more general phenomenon known as gravity, and that we can produce broad explanations which, among other things, show why the Earth orbits the Sun in a particular way, and that the Sun in turn has position and relationship with other stellar bodies. Typically, we are able to derive a scientific law by making an initial observation, given a provisional hypothesis which explains what has been observed, providing a means of testing the hypothesis, and actually testing the hypothesis, the experiment, for example, and examining and analyzing the result of the testing to see that they conformed with expectations or some revision thereof, saying that the hypothesis is now a scientific law that holds good for a given range of phenomenon and which can be published as such. So the process is known as the scientific method. The end result of the application of the scientific method is a scientific law. And then we have, the court proceedings, for example, a witness and a case, it may took, the legal, it was the legal decision making. This takes us neatly to the next issue to explore the relationship between a finding by forensic scientists and the decision of the court. Put bluntly, if a forensic scientist were to state in evidence that there is a probability of 1 in 1 million that a DNA sample found at the scene of a crime matches the DNA profile of an accused, then would be the court be bound to accept his findings. So many things. Thank you very much.
Thank you very much, Mr. Basilio, for putting the scientific methods and DNA profiling in terms of the evidences to prove the case. And also, we know very well these are very, very important area to explore, because if you get any parts of the kind of the culprit, maybe in terms of the blood sample or any hair fall, and you can also know very well that by analysis you can find out the DNA, and by DNA mapping you can find out the person who was the criminal. So thank you very much, Jersa, and also the Vasilio, for bringing your kind of opinions and about your points about the e-discovery and the role of the evidences in terms of the forensics. Now we'll come back to Dr. V.P. Tiwari,
Thank you.
and I would like to hear from him that what is his view in terms of e-discovery and also the forensic science for evidences.
Thank you so much, sir. Thank you so much. Very good evening to all of you. I do not know whether it is evening or noon at your place, but whatever it is, greetings from my side. It's the 13th annual international conference and 75th Constitutional Day on Law and Policy Issues being organized by Indian National Bar Association. I must congratulate Indian Bar Association, National Bar Association, for organizing this conference and inviting me also for this conference. The topic is very important, as has been said by the chair, Professor Tabrez Sahab. But before I switch to this topic, I just wanted to tell that any Constitution Day celebration will not be complete unless we remember the architect of this Constitution, Dr. Ambedkar, Dr. B.R. Ambedkar. So with the kind permission of the chair, Professor Tabrez, I just wanted to give a little reflection on what Dr. Ambedkar felt when he was trying to speak in the Constituent Assembly in the last day. One of the worries of Dr. Ambedkar was that India is going to be free on 26th January. India is going to be the federal country, a republic, on 26th January 1950, and after attaining the freedom. However, he was much concerned whether this freedom is going to long last or not. For the fact that India was free earlier, India had democracy earlier, but at a later point of time, it became a colony. It was being ruled earlier by the Mughals and later by the Britishers. So he says that the most important thing, India is already divided into caste and creeds, and now politicians are going to have their own political party. and they may divide the country in yet another manner of the party support basis. These days, we are able to see that politicians did not hesitate in spreading the false news, and this has become very easy with the advancement of technology. So this false news which is being spread in favor of their party and dividing the country, which goes towards even murder. Day before yesterday, four innocent people were killed because of some political parties. So what I'm worried that it is the freedom. Dr. Ambedkar also worried that India is going to have the political equality, meaning thereby that one person, one vote, one value. But what about social equality? What about liberty, economic, political, and social? He wanted that everybody should be given this, otherwise we may lose our freedom. I just wanted to emphasize, sir, I'll take 4 minutes, not more than that. The Dr. Ambedkar said that in free India, there should not be any scope of dharna, pradarsan, protest, or whatever it is. He said that this could have been possible when there was no constitutional mechanism of solving the problem. Now, because we are having the constitutional mechanism to solve our problem, these should be abandoned. The protest, etc., should be. And he compared this type of protest, etc., to anarchy. And I appeal through this conference that in our country, we have well-established courts, we have the political system, and we should resolve to them and